Okay, the icon is up in your left, top left. This is the case of Allison Bozovich, once formerly known as Allison Carpenter versus Signature Day Spa LLC, also known as Signature Nails and Day Spa. And this is civil action number 2021cv352194. Today is March the 14th, 2022. And we are here today on, I believe, the defendant's motion to stay. So very quickly, if we want to do some introductions, I'm Jane Barwick. Ms. Whitt, you want to go next?
Yes, I'm Susan Whitt, counsel for plaintiff.
Okay, Ms. Whitt, it's good to see you. Mr. Emanuel?
Thank you, Judge. Joseph Emanuel on behalf of defendant, Signature Day Spa.
All right, and Mr. R.
Mr. Ross, sorry, Judge. I don't know why I didn't say my whole last name. Brian Ross, I'm here on behalf of the plaintiff, although Ms. Whitt will be handling the hearing. I'm more of an observer.
Okay, well, it's nice to have you observing. And therefore, Mr. Emanuel, I think you're up.
Thank you, Judge. May it please the court. As I said, I represent defendant Signature Day Spa. I think that I'll be relatively brief. I think this issue is fairly straightforward and well briefed. We filed the present motion simply because an ongoing conflict with our insurer, which is now being resolved in a separate civil action, is prejudicial to my client, Signature Day Spa. And to be candid, Your Honor, makes it difficult to fulfill my basic professional obligations with respect to my client in this case.
Do you actually represent the spa itself, or do you represent the insurance company?
Judge, I represent the spa, defendant Signature Day Spa, pursuant to a traveler's insurance company commercial general liability policy.
A reservation of rights, or?
Yes, Judge. So just to give a brief timeline, the plaintiff notified travelers of the subject claim in 2019. At that time, travelers issued a denial of coverage to my client and to plaintiff. In 2020, plaintiff sent a time-limited demand for policy limits. And at that time, travelers filed a declaratory judgment action in federal court, which was dismissed on procedural grounds. In 2021, plaintiff filed the present suit, the case before this court. At that time, yes, Your Honor, travelers sent my client a reservation of rights, but appointed us to represent them pursuant to the traveler's policy. However, they have consistently and emphatically denied coverage at every single stage of this claim. And in this case, as would be expected, they have filed a declaratory judgment action, again, emphatically and consistently denying coverage. And that has made our ability to fulfill my professional obligations to my client profoundly prejudiced. I have not and cannot obtain settlement authority or evaluate my client's potential personal exposure. We also risk taking inconsistent or having my client take inconsistent positions in this case in which I'm representing them, and in the simultaneous litigation or dealing with inconsistent orders between this court and that court. That is why when a coverage dispute is being litigated at the same time as a suit arising.
Where is it being litigated? Because you told me the federal, I know where it's being litigated, but what happened between the dismissal of the federal action and it ending up in Fulton Superior?
So the United States District Court dismissed the first declaratory judgment action, which was filed by travelers before plaintiff filed a lawsuit. That was in response to the time-limited demand. That was based on diversity jurisdiction, and the court, in an order which I attached to my reply brief in support of the present motion, the court said that the plaintiff's incurred damages were so low that the amount of controversy requirement could not possibly be satisfied. So the court found that it lacked subject matter jurisdiction and dismissed the declaratory judgment action without ever reaching the merits. So Now, as I said, at every single stage, Travelers has emphatically and consistently denied coverage. So now they've filed a declaratory judgment action on the exact same issues with the same merits. They filed it now in the Superior Court of Fulton County.
Okay. Have I heard anything in this case before?
No, Judge, we have not appeared before Your Honor.
Okay.
We have filed a motion to dismiss. I apologize, Your Honor. I didn't mean to interrupt.
Well, Ms. Cummings is going to kill me. But I do need to tell you, and I haven't had to tell anybody this in a long time, but I am a former partner at Swift Curry McGee and Hires. Regretfully, their financial responsibility to me ended in about 1996. Love them to death. They don't owe me any money. I don't know Mr. Emanuel. I know many partners there with whom I practice, but I think there's probably been a whole sale overdue since I was last there in 95. Unfortunately, the procedure, I think, is for Ms. Whitt and Mr. Ross to talk to their client. So even if you wanted to tell me that that made no difference to you, and it may make a difference to you on its face, I don't even think that I have to do this candidly, but I don't think a little caution ever hurt anybody. I think it's incumbent upon me to say that you need to talk to your client and disclose the possible ancient tie. What do you think?
I mean, Your Honor, we will absolutely disclose that to our client. I have worked with you before, though, and find you to be fair and impartial. And
see, Mr. Emanuel, this is always what happens. There's always it's always the people you're disclosing to that end up being so darn nice. Go ahead.
Well, I have been in front of you before, Your Honor, and have found you to be fair and impartial. And given the length of time in which you have been at Swift Curry, I don't see that as, entirely problematic. I mean, of course, if we're obligated to discuss this with our client, Mr. Ross and I sure will do so. But I mean, at this time, I personally don't see an issue based upon my prior working with you. And I don't think that would cloud your judgment in this case.
Might I suggest this? And I reserve the right to be wrong on the procedure. I know you have to talk to your client before you can waive anything. And I agree. I don't think there's anything to waive, but again, might I put this suggestion out there that I go ahead and hear your arguments without deciding. And then you can get back in touch with me. And then I can, in the meantime, I'll have it under advisement so we don't have to reschedule this. Or we can reschedule this at your convenience.
I think our preference is that we're here and we're ready to move forward, if that would be all right with you. And we certainly want to respect the court's time, and we figure that this would be the most efficient way to address the two issues that we have. And then Mr. Ross and I will certainly disclose to our client your prior relationship that it's in excess of 20 years. Is that right?
Gosh, yes.
Okay.
So I left there on March 1st, 1995, and then had a buyout, which was over, I think, in 96.
It's like 26 years. Yeah, I agree with Ms. Whitt. I think we should just move forward and then we'll take it up with our client. But I don't.
Okay. Do you have any objection to any of that, Mr. Emanuel?
No, Judge. We appreciate the court's caution and prudence, and we're happy to move forward however the plaintiff and the court would prefer.
Okay, go ahead. Keep going, Mr. Emanuel.
Well, Judge, when I started talking, I said I wasn't going to talk for very long, so I want to keep my word. I'll just tell Your Honor from the very beginning, as we discussed, Travelers has emphatically and consistently denied coverage at every stage. It's causing real prejudice to our ability to represent my client in this underlying litigation. And that's why when a coverage dispute is being litigated at the same time as a suit arising from the loss, which it may or may not cover, the Court of Appeals has consistently explained and emphasized that it is of, quote, exceptional importance to know at the earliest possible moment whether the policy covers the loss or not. That language is from the Stinson against Allstate case cited in my briefs. And our appellate courts have repeatedly explained that the proper mechanism is for the trial court to stay the underlying litigation while the coverage issues are resolved. This is a case where I think that remedy is vital and important to protecting my client's interests in this underlying litigation. And the reasons why we think it is appropriate are further set out in our briefs. Unless the court has further questions for us at this time, I'll just submit those arguments to the court.
Well, I think the logical question is, what you may know, are you actually involved in the action before Judge Dunaway?
No, Judge. We have no involvement whatsoever in the coverage litigation. There is separate counsel that my client has retained for purposes of litigating that action. And I have no involvement. I have no communications at Travelers on the coverage side whatsoever. And I have no involvement in the coverage, in the litigation of the coverage action.
Okay. So in question number 2 then would be, might the outcome of that case mean that you, Mr. Emanuel, are no longer involved and that defendant would have to get new counsel?
Absolutely, Your Honor. It may also require them to repay the costs of everything I do including this hearing, between now and the time that such an order is rendered in the coverage action, which is just another reason that they are being potentially profoundly prejudiced by the concurrence of these 2 cases.
Okay, so, all right. And I'm going to ask someone whether they are aware of the timetable with the other case. So that would not be you who could answer that.
That's correct, Your Honor. That's okay. Correct.
All right, Ms. Whitt.
Thank you, Judge Barwick. First of all, I just wanted to give you a little bit of history about this case because there's been some confusion perhaps in the pleadings. This case involves our client, Allison Bozovich, who at the time that this injury occurred was Allison Carpenter, who went to this day spa nail salon to have a waxing procedure done. The injury was sustained during the waxing procedure, which was done incorrectly by an unlicensed individual. And there's no dispute that the person who performed the procedure was unlicensed. Of course, Ms. Bozovich did not know that at the time. Our complaint, though, that is before your court is not against the individual who performed the procedure itself. The basis of our complaint is all the things prior to the procedure taking place were negligent under the corporation. We've only pled our case against the corporation, and they're for the corporate negligence of the systemic and chronic practice of negligent hiring, training, oversight, retention, and hiring individuals who are not qualified to perform the services that they're offered. Are the basis of our claim, and it's clearly pled, that these negligent practices create a dangerous condition for business invitees to the premises with the foreseeable risk of harm to that invitee. We believe and are very confident that these are all covered claims. While we are dealing with the DEC action in the other court, these claims were carefully pled, and they were pled within the context of coverage that is afforded within the policy. So we do believe that this case is going to continue before you in this court. We understand we've got to get through the DEC action first, which I believe the answer will be, we've already filed our answer and our motion to dismiss. And the time frame, I believe, for the council for signature to respond has been extended to, was it the first or second week in April, Brian?
I think it was something, yeah, yeah. I think
So we would expect the court to rule on that motion to dismiss, sometime in the next 60 to 90 days. And I strongly believe that that will end the deck action and we will be back in front of you. In most cases, I do agree that motions to stay the proceedings are appropriate. We deal with this a lot of times in cases where there's bankruptcy issues, and we have to make sure that the case gets removed from bankruptcy. This case is a little bit different to me, and it is peculiar because we did file this case on July 20th of 2021, and defendant answered on September 7th, 2021. This was after we had ended the deck action in federal court. So everyone knew what these claims were about, except that the claims that we did file in our complaint in your court were different than the claims that were filed and addressed up in federal court on the deck action, because we did not have any claims against the individual who actually performed the service. All of the claims here are against the corporation. At the time that the defendant answered on September 7th, no defense was raised to coverage and no deck action was filed at the time of the answer. I understand that, it's not the defendant who is, or defense counsel who is defending the insured makes that determination. I understand it's the insurance company who will ultimately make the determination of whether they're going to move for declaratory judgment. So after the answer was filed on September 7th of 2021, the parties continued to participate in discovery for months. And on December 17th, after we had been pursuing discovery for several months, a deck action was filed by Travelers. Interestingly enough, though, and this is where the case becomes of concern. The deck action was filed in the middle of December. Defense counsel, who's before this court today, continued to work the file. The defense counsel called me personally and expressed that the adjuster on the case, the same adjuster who has sent the case to be filed for deck action, would lo and behold now like to go to mediation. So on one hand, they filed a deck action, but on the other hand, they're asking us if we would like to participate in mediation, because we've gotten into some nuts and bolts of discovery that I think got a little uncomfortable for them. So we have a deck action filed simultaneously with an invitation to go to mediation. And there's numerous exhibits that we had attached to our response that indicate that that communication was taking place. I expressed to defense counsel that this is not my first rodeo with Travelers over this identical type of injury. Back in 2016, I had another case. The Travelers was the insurer of the day spa at issue. They did not file a deck action before mediation, but at mediation, they used the threat of a deck action to try to bring the value of the case down at the course of the mediation, and stating that if we didn't settle at mediation, that a deck action would be filed and this would get, our case would be prolonged as a result thereof. So the problem that I have here is that I do feel that the deck action that was filed in December, months after the case had been filed anyway, is used as a strategy and a tactic to try to reduce the value of plaintiff's claim at mediation. Now, this case hasn't been set for mediation because the motion for stay got filed at the end of January. We were put on notice on January 25th that the motion to stay had been filed. Ironically, once I receive a motion to stay, I don't do anything in the case until the court has ruled on it, because I feel that would be inappropriate on my part. Ironically, though, the file has continued to be worked by defense counsel even after he filed his motion to stay. There's communication about depositions. There's communication about a site inspection that we would like to do of the facility. There were objections filed to that site inspection. We've done nothing. Once that motion to stay got filed, plaintiffs appropriately did nothing. It's actually the defendant's conduct that shows that this motion to stay was really just more of a tactic, because once again, we feel like Travelers is trying to utilize these different avenues to lure plaintiff to mediation, only to push these legal tactics as a means to reduce the value of the case. So I understand in theory the argument that if a motion to stay is not granted, that a defendant could be prejudiced because of incurring defense costs. The situation in this case, though, is defense costs have been incurred because it is defense counsel that is continuing to work on the case while a motion to stay is pending, which it's inconsistent with each other. So,
Ms. Whitt, let me ask you a question, and this may or may not be fair, and I've intentionally not looked at the record in the declaratory judgment action. Maybe I should, and maybe I should have, but I felt like I would err on the side of not doing that before I heard this. But is there involved here, I guess I'm trying to ask a weird class action case. Is your case against this corporate defendant, the one in front of me, purely as it relates to your client, or is it intended to invite other plaintiffs?
no, absolutely not. This is only for our client individually.
Okay. Okay, and the reason that I asked that, other than the obvious reason, is just simply to see so the impact of the stay is not only, because I get it, but the impact of the stay is as to Ms. Bozovich only.
That would be correct.
Okay.
And Your Honor, I mean, we understand that motions to stays are typically granted, and I understand the reasons for that. It's just when a motion to stay is being filed that seems like it's more of a litigation tactic, it's concerning. It's also concerning when defense files a motion to stay claiming that they're profoundly prejudiced by continuing to work on the case and incurring fees and expenses, but then they're the ones who continue to work on the case and incur the fees and expenses. That is wholly inconsistent with asking you to stay the proceeding.
Okay, now when did the individual did she get let out?
We did not ever file her a case against the individual.
Because this has the same, and Jessica, tell me if I'm wrong, this has the same civil action number, 2021cv352194, and it looks like the original complaint included Trang Nguyen Thi Tran as a defendant.
Well, okay, that was not the individual who performed the proceeding. These were individuals that perhaps had ownership or operational.
Okay.
They had nothing to do with the individual who performed. Those were more about who was running and operating the business itself.
Okay.
But it is now a one defendant case, one plaintiff, one defendant. We've already stipulated that plaintiff's claims, assuming that they're covered claims, which we believe they are, would all fall under the coverage that is provided to the corporate defendant.
Okay.
So we
Anything else?
tried to clean the case up as much as possible to streamline it a little bit. So I hope we've done a good job with that.
Okay. All right, Mr. Emanuel, any response?
Yes, Judge. I think it is important that I briefly respond to this suggestion that the deck action, which of course I can't speak to the merits of, or to frankly the timing of, because that is something completely separate from anything that I have exposure to or involvement with. But the idea that it is a coordinated and calculated conspiracy to being used as a strategy in this case to devalue plaintiff's claims in this underlying liability action, I think is, first of all, belied by the fact that at every stage, from beginning in 2019, Travelers has emphatically and consistently denied coverage. In 2019, when they were first notified of the claim, they denied coverage. In 2020, when there was a time-limited demand, they filed a declaratory judgment action. And now, in this case, I certainly wish that they hadn't. I hope that the plaintiff prevails and that there is coverage, because that's what's in my client's best interest. But of course, they filed a declaratory judgment action now that this case has been filed as well. So the idea that it's done, that the underlying, that the deck action was filed for any reason other than the fact that Travelers believes in the merits of the deck action, I think is clearly belied by the clear history of their emphatic and consistent denials of coverage at every single stage. My friend, plaintiff's counsel, Ms. Whitt, suggested that it was the adjuster on the liability file that made this calculation to, at the right time, pull the trigger on a deck action. That simply isn't how it works. The adjuster on the liability side has nothing to do with the coverage side at Travelers. I can advise on the liability side about exposure and mediation and settlement. And to be completely candid to the court, the adjuster on the file on the liability side, who I work with, would love to provide authorization and move forward with settlement negotiations. We can't, because Travelers, we cannot obtain any authorization whatsoever, because our hands are tied on the liability side because of this separate, simultaneously pending coverage dispute. Now, Ms. Whitt spoke a bit about the merits of the coverage dispute. And as I told the court, I can't and don't have an opinion about that. It seems relatively straightforward to me with regard to the individual being unlicensed and there being exclusion for that in the policy. And Ms. Whitt said that her causes of action might get around that, in which case we would likely file dispositive motions about whether she can pursue those causes of action, which would be a basis for potentially inconsistent orders in the two simultaneously pending actions. But regardless of what the merits of the coverage dispute are, it is clear that Travelers believes in the merits of the coverage dispute. And I think it's clear from the history why that coverage dispute was filed. And it's not because there's a coordinated, calculated conspiracy to, at the right time, pounce and trying to value this claim for purposes of mediation. That simply, Your Honor, as there's no factual basis for that. And that I just simply want to reject that characterization and say it could not be true based on the timeline and the history of this case.
I'm not nearly as worried about the ultimate bucket out of which any recovery would come as I am the representation.
Yes, Judge. And that is really our most significant issue in terms of we have professional obligations to our client that we have to fulfill, and we have obligations to the court that we have to fulfill. So
Ms. Whitt mentioned that on the plaintiff didn't make you do it.
Well, respectfully, Your Honor, Ms. Whitt has said that we've continued to litigate this case. For example, we responded on February 23rd to their notice to conduct a videotaped inspection. Now, OCGA 91134B required us to respond to that within 30 days. Discovery is going to close at some point in this case. We have professional obligations to our client and obligations with respect to mandatory compulsory discovery under the Civil Practice Act, which we have to continue fulfilling with respect to our litigation of this underlying case. We have professional obligations with respect to diligence, and we have no choice but to respond to pleadings filed by the plaintiff and respond to discovery requests made by the plaintiff.
Okay,
as we
let me
continue.
ask you this question.
Yes, Judge.
And this is going to be your typical kind of middle ground, but one of the many reasons, but one of the reasons that a court would frown upon a stay is that evidence isn't getting any fresher, memories aren't getting any clearer, and whatever happened on this particular incident is getting further and further away in time. Is there any way to continue, just to finish up discovery at least? So if an answer was filed in September, discovery is nearly about over, isn't it?
Yes, Judge, which is one reason that I think that the stay is so important. But I would just say, Your Honor, I don't think that there is a significant risk, especially given the way that Ms. Whitt has described her claims in terms of dealing with corporate operations. I don't think there's a particular risk that anything that it currently exists is going to be lost with respect to the claims that she is prosecuting or attempting to prosecute in this underlying liability action. So I think that there isn't a risk of prejudice of plaintiff to plaintiff in that regard in this action as there might be in some cases.
Your Honor, may I respond?
Of course.
Thank you. Your Honor, I do agree, and I have some of your concerns as well. It is twofold. The nature of the individuals who work in these salons, they tend to be rather transient. While we do not have any claims specifically against the individual who performed the service on our client, because all of our claims are as to her employer, we do have concerns that she is a transient individual. In fact, she's not even licensed in Georgia to perform the procedure. She's licensed in another state. She may be leaving to go to another state, and then we won't have subpoena power over her. And she is a fact witness to this case. She's a critical fact witness. And, in the passage of time, we may lose the ability to depose her. I've been asking for her deposition actually since October. And that kept getting pushed down the line. And I still have yet to take her deposition, despite the times I've repeatedly asked for it. And that was before the DEC action was ever filed. And even after the DEC action was filed in December, there's correspondence from defense counsel in early February wanting to go ahead and set up depositions for March. So clearly we have a DEC action that's been on file for a month and a half. He doesn't seem too concerned about it if he's wanting to set up depositions in March. But we did not feel it was appropriate to respond to his correspondence in that regard until the court had heard this motion to stay. We've also filed a request to go in and do a video site inspection of the facility. I would like to proceed with that. I am concerned that with the passage of time, things there may change. There are some things within that site inspection that we also would like to address today that we asked for the court to hear, and we can get to that in just a moment. But I would certainly want the ability to take the deposition of the individual who performed these services because she may leave. And I would like the ability to go in and do the videotape site inspection before there are any more potential changes to it.
Okay, what's your next argument? You
Well,
said there was something else.
So we filed a notice of videotape site inspection to the defendant, and they filed an objection to some of the areas that we asked to go and be allowed to inspect. And so
Does everybody agree that's being heard today? Because I didn't have that on the calendar.
Yes, Judge, it was actually included in the request for oral arguments that was filed, I believe, on February 25th.
Okay, so it's a motion to videotape the premises?
well, we filed a notice to conduct a videotape site inspection, and the defendants filed a response objecting to some of the areas that we had requested a videotape.
Okay, and that's definitely before me today.
Judge, just if I may, on behalf of defendant, I would represent to the court that it is not properly before the court. As Ms. Whitt represented, she did serve a notice to conduct a videotape inspection. That's done pursuant to CGA 91134. We served a response pursuant to OCGA 91134B2, which sets out the procedure for a response to this particular discovery tool. I have no idea sitting here today what Ms. Whitt's potential issues are with regard to her request or our response. It is, I think, indisputably subject to Uniform Superior Court Rule 6.2. Her issues may be something that we could very easily informally resolve. But because there has been no communication with respect to her request or our objections, I don't think it's proper to be heard by the court.
I don't know what it is.
The plaintiff served, like I said, it's pursuant to the Civil Practice Act, just the discovery tools. 91134, which is the depositions and discovery statute. And we served objections. And I do not know what Ms. Whitt's.
I'm sorry, I'm looking at the wrong, let me just get it.
I'm happy to
Yes,
hear.
what's on today?
Well, my understanding was we were hearing both today.
Jessica?
It does say right motions. I guess it's a little quirky since it's a notice and not necessarily like a motion to compel the video. So I think that's just the quirk.
I don't know if this will help. Part of the issue in the notice for site inspection is an issue that we have been having in discovery, that I think we had emailed the court asking for a discovery conference so that we could handle how we wanted to approach that particular dispute. But the dispute is the same within the notice to conduct the video site inspection. And there's areas in the video site inspection we both agree on. There's just one area that we don't, that I'd like to have the court hear today, because if the court is going to allow the case to continue, or if we could be permitted to do some minimal discovery to preserve evidence before we have more delay in time, we would ask that we be allowed to depose the individual who performed the waxing services, because she is a person with knowledge of relevant facts and she may not be here down the road. And then we would also like to conduct the video site inspection to preserve that evidence so that it's as fresh as it can be for when we go to trial.
So I have the notice of the notice to conduct videotape site inspection filed on January 24th. And then Ms. Whitt, you referred to a response or an objection by the defendant, and that I don't see that on the docket.
That was on February 23rd that was filed.
He did file with the oral argument request. I see that in the title. But so that's what I'm saying. That's the quirk in it, is that, and I'm not exactly sure about the letting us know ahead of time about, I'm just checking my emails and I get so many discovery disputes that we
love one-stop shopping. We love judicial economy. I just don't like blindsiding people if they weren't ready. So if you're able, what's the problem? What don't they want you videotaping?
Well, Your Honor, the one area that we would like to go in and videotape that they have objected to is all areas where licensures are supposed to be posted. Part of our claims involving the corporate claims have to do with a chronic practice of this facility hiring unlicensed workers to perform the services, which are in direct contradiction to what is allowed by the Department of Cosmetology in the state of Georgia. And that is a problem. And it's evident through the reports that we have, inspection reports through the facility as well. And so in terms of, we've asked numerous times for copies of the licenses of the individuals who worked at the salon during the period of time that would be relevant. We have been met with nothing but refusal to produce those licenses. Those licenses by law, by rule 130-4-.08, pertaining to posting of licenses, rules, reports, and inspection reports. Signature Day Spa is required to have those licenses posted at each workstation for the licensed individuals who are going to be performing the services. And we have gone every which way to Sunday to try to get these licenses out of the defendant in discovery, and they have not, they refuse to provide them. So during our site inspection, which we'd like to go see the facility, we would also say that we would also like to make sure that they have these licenses that they are supposed to have posted that they say they don't have, which they're obligated by law to have, not only to have them, but to have them posted. And they're supposed to have the license from the state, for the Department of Cosmetology to run the facility for each individual. And they're supposed to have their last inspection report posted. And we would like for that to be part of our site inspection, where we also want to go and see the room where this procedure occurred. We want to go back and see where the machines and the equipment are stored. That is part of our claims as well. And they have objected not to allowing us to come and do a site inspection, but they don't want us to be able to go and look at other people's licenses to see that they're posted as they should be. And they do not want us to go back into rooms where supplies or equipment are maintained, even though those do relate to our claims.
Okay. And then what's the problem with the deposition, Ms. Whitt?
Well, we haven't gone forward with it because, number one, they had filed a motion to stay, and I thought that that would be inappropriate for us to push on that until you had the ability to hear this motion to stay. And second of all, there was no ability for us to go forward with a site inspection when we had areas that we were not able to agree on as to the scope of the site inspection. And that's what we asked the court to hear today, as well as the motion to stay.
Mr. Emanuel, you want to respond to this, or?
Yes, briefly, Judge. I mean, first of all, to be clear, I filed responses to the plaintiff's notice on February 23rd. Since that time until 3 minutes ago, I had no idea what, if any, objections they had to my responses. I'm hearing now for the first time, again, there was no communication pursuant to Superior Court Rule 6.4. And I think all this could be worked out rather easily through a phone call. But I'm hearing now that the court is being told that, well, that the issues are they want to videotape all areas where licensure is required to be posted. Well, I don't know what the plaintiff means by that in terms of where does the plaintiff contend that licensure is required to be posted. That's something I need to discuss with plaintiff's counsel and determine what she means by that. And then in terms of anywhere supplies or equipment is kept, well, that I don't know what is meant by supplies and equipment or kept. That could be anything. And so OCGA 91134 says that the notice is required to set forth the items to be inspected and describe each item and category with reasonable particularity. When I was drafting this response, I did not feel that those items were described with reasonable particularity or set forth in the manner they need to be pursuant to the statute. So that's why I set out relatively simple and straightforward objections. I would have greeted an opportunity to speak with plaintiff's counsel pursuant to the Uniform Superior Court Rule 6.4 and easily work out these issues. I have not had that opportunity. And as I said, I think that these can be resolved as they're required to be resolved informally between counsel. I simply don't know exactly what is being referred to by these paragraphs based on the language of the request. And there's an ancillary issue related to these licenses, which plaintiff's counsel on the one hand says we must have and be withholding because we're required to have them. But at the same time, Your Honor, in her complaint, she alleges that we don't have them pursuant to that we violated the regulations that require us to have them. So that's certainly inconsistent, similar to the inconsistency of, on the one hand, in the motion to stay, accusing us of improperly engaging in discovery, and then also telling this court that we have not engaged in discovery on these other issues. I think that both issues are relatively straightforward, Your Honor. I think that we are being prejudiced by I think we're entitled motion to stay, and that this other issue isn't right before the court. Thank you, Your Honor.
I have a serious character flaw as a judge, and I want to be forthright about it. I love discovery disputes because I love to solve them. And I'm just a peculiar judge. I love doing it on the telephone. I love doing it every opportunity I can. And I rarely turn down an opportunity to do it because it's usually a pretty good faith impasse. And people just can't get beyond what their clients want them to do. And I love that. But there is a procedure. And I think it's fair to rely on procedure, Ms. Whitt. And I think that the rules contemplate the step which might be unnecessary or might be useless, which is sit down and talk about it. If you're thinking that you're going to get right back to the same place, but I think you got to do it.
And Your Honor, we have. That's the problem. We have, it's reflected in a lot of the correspondence that are on in the exhibits. We have gone back and forth about this licensure over and over again, and they are required to have licensure. Now, the person who performed this procedure, we know didn't have a license. We do believe that they are employing or having a lot of other people work there who don't have licenses either. So if they want to stipulate that they don't have any license for any person working there, great. That supports our claim even more. But they're supposed to have licenses for the individuals working there at their station if they are complying with the rules and regulations in which they're to operate.
Have you gone back and forth about the issue of videotaping the room in which they're supposed to post them?
No, Your Honor, we have not.
Okay.
We have been met with resistance every time when we're asking for the licenses in discovery, and therefore we included that, as I have done in other cases, because I've handled other cases like this, and we've gone in and done the video site inspection. I know where those licenses are supposed to be. It's fair game because of the breadth of the claim. These are not claims just in a vacuum of what happened to Allison on that day. These are claims that involve all the negligence leading up to that day that caused the problem. So
okay, I think the prudent thing for me to do here is say noted.
Okay.
And if y'all can't talk about it, I mean, are you asking to videotape what's there now?
Well, we've asked, I mean, we would like for things to look as they were, as close or similar in the time that the event took place. But, there does seem to be a chronic problem of they're either hiring people who aren't licensed or they're not complying with the law and posting the licenses as they're supposed to. It's one or the other.
Okay. All right. Ms. Whitt, Mr. Ross, talk to your client. This doesn't have to be formal. If you want to just send Ms. Cummings an email and copy Mr. Emanuel, and I will go ahead at that point and either recuse or I'll decide the motion to stay.
Okay. So I mean, to be candid, I mean, we will recommend to our client that we proceed with having you rule over this case. I know that Mr. Ross and I don't have an issue with that, but we will do the right thing to confirm with our client. And then we'll
As I
just go ahead
said,
and-
please do it informally through Ms. Cummings, and then we'll go from there. And it was great seeing you guys today. Everybody's so smart. You're actually kind of smart enough to settle this.
Yeah,
We're
I
hoping,
mean,
yeah, we're hoping.
We're
that's
we're
the direction I
And
thought we were
I
going.
doubt, Ms. Cummings, did we deliberately not send it to mediation? Or have we just not sent it to mediation yet?
It has within the case management order, certain deadlines for when they should have mediation completed by, should they choose to go to mediation.
Oh,
I'll just represent to the court, we're unable to obtain any authorization for mediation because of the deck action. As I
And
Well,
I
addressed
find that
earlier.
so curious because we were invited to mediation after the deck action was filed. So that is
See, I don't
difficult for me
think-
to rationalize.
Right.
I don't think Judge Edwards, and I was wrong, it's not Judge Dunaway, it's Judge Edwards. I don't think Judge Edwards would be mad at me for resolving 2 cases.
She'd probably thank you, Your Honor.
I'm thinking I might be invited to the Edwards family Thanksgiving.
With the current backlog in Fulton County Superior Court, I could imagine.
We got some stuff to do down here.
Absolutely. Used to be
but
an
if you-
agency down there.
If you'll just do the step 1, we'll do step 2 and start thinking about step 3. Okay.
Thank you, Judge.
Thank
Thank you,
y'all so
Judge.
much.
All
All right.
Thank you.
Talk
Thank
to you guys later. Oh, wait, I gotta take